attorney? See any?
I'm here, Your Honor.
Okay. Okay, we're back on the record in that matter. Did you all discuss and come to resolution at all, or are we moving forward with the motion?
Yes, we did.
Yes.
Okay, how do you want to proceed on this?
Your Honor, I spoke with Mr. Hall, and he is going to agree to withdraw his motion to set aside, but that we're going to do an installment order for $250 per month, beginning, I believe it's 12/12/2024, the same date that he requested on his original motion. Just a lesser amount. He said that, $500 is not really feasible for him anymore. And so that's the agreement that we had.
That's what you want to do, Mr. Hall?
There was also one thing I wanted to add that we had discussed at the end of the call.
Yes.
Um, with the last couple of weeks, with the amount that they've been taking, I've been dealing with a lot. I'm supposed to be going to Atlanta to see my son next week, and I was wondering if there was, since we've came to this agreement today, right now. Normally, my payroll for my job gets released today around 4:30 or a little bit later. I was wondering if there's any way possible that you can email me something or email my job something in which they can stop my garnishments right now, in which I don't get garnished for my check again. So I would be okay to go see my son.
Another question for Mr. Schussler, or were you asking me that?
That was for you. I asked Mr. Schisler. He said the only person that would be able to, report to my job and get the garnishment to stop immediately would be you and your signature.
I can certainly send an email, Your Honor. I just was letting him know that sometimes the
Oh,
payroll companies
yeah.
want to see an order before they will stop withholding under a
Yeah,
guard.
yeah, a court order. He had said, yeah, if that's something that's possible, I would really appreciate that. If not, I completely understand.
Okay, let me first, you're gonna withdraw your motion, and you all have entered installment payment order. What is the monthly amount that's gonna be paid? Mr.
Two
Schisler,
fifty.
$250.
beginning when?
12/12 of 2024.
I believe it was an order. Okay, I am going to first I'll amend the order that was already in here that request payments for $500 per month, beginning 12/12, amend that to 250, and I also select paragraph 5, which will suspend any garnishment order. Is that what your concern is, Mr. Hall?
Yes, ma'am.
Okay, so I'll sign that for today. And the clerk's office will send a copy, but I don't know if it will be beneficial to you to get a copy that you can get to your office sooner. If that's the case, then a council might be able to send a signed copy quicker than you can. I'm not sure. I'm gonna sign it today and it'll be entered in our online filing, which I know Mr. Hall does not have access to.
Yeah, is there any way you can email that to me as well, or anything like that, so I can take the copy up to my job? That'll possibly be an option too.
What's your email address? Someone email this after I sign it.
All right, you ready for it?
Yes.
It's gonna be O Paul 4328 at iCloud.com.
Okay, we'll get that over to you shortly. Any additional matters for today's record, council?
No, Your Honor. Thank you.
Okay, you're all set for today. Thank you.
All right, thank you.
Where are you gonna get that out of here, honey? Is it- I don't even know if it let me save it, you know, after I completed the hearing. So that you be able to, are you able to go in and put that document that you want? I wonder if it depends on if it's in the file cabinet. Okay, it was in the file. I don't know if they have to like do something for. Oh, wait, hold up. This is here. Let me see if I can put it. Okay, I see it here. Let's see if it lets me print. You're right, guys. Yeah, we can give it to you. Maybe she can. Yeah. Is there anyone here? Is there anyone here? Oh, yeah. Well, Judge, it doesn't have your changes on. See? I changed it in the system, so we don't need to scan that. That's just to send to his first job. He needs it.
Email it to him.
Mhm. Oh. Who's in the hallway? Miss Green's on the hallway?
She's in a conference room.
Mr. Werber's on here.
Yep, she should be making her way back to the courtroom right now, Your Honor. We were unable to resolve it. I'd like to move forward with my motion.
She should be in the hallway. We're back on the record in the matter of Calvary versus Joy Green. Okay, Ms. Green, you met with Mr. Werber. He said you were not able to come to resolution. He has filed a motion for summary disposition indicating that you owe a balance of $3,649. You're disputing that amount?
Yes.
What are the reasons for the dispute?
At this point, I would like to, he said we could go ahead and meet again in court, a non-jury trial, because at this point, I have not.
I did not say that. Never said that.
Okay. Anyways, I would like to seek legal help with pursuing the remainder of this.
You want to get an attorney? Is what you're saying?
Yes,
Okay, and you're expecting the attorney to review the motion and respond to it?
yes.
How much time is it gonna take you to get an attorney?
I have received in the mail a lawyer who was interested in doing a free initial meeting with me and is aware of this case.
How long is it gonna take you to get to
I
retain
can
them, do
call
you think?
today to see if I can get an appointment.
Okay, so I'll get you your our next available court date.
Thank you.
November 8th at 2. November 8th at 2 p.m., okay?
Okay,
We'll get you notice to appear. Your attorney can file an appearance, and if that date is a conflict, they'll file a motion with the court where they can contact Mr. Werber and stipulate to a new date, okay?
okay.
We'll get you a notice. Any additional matters for today's record, counsel?
Nope. Thank you, Your Honor.
Thank you. You're all set, ma'am.
Thank you. Thank you, Your Honor.
You're welcome. Wait for your notice, please, though, ma'am. You can wait for your notice for the new date, okay?
Okay, thank you.
You're welcome. Is Lynette Farr here? Anybody here by the name of Lynette Farr?
There's some car that I checked in. We have,
James Gomez, attorney. Okay, Joe Chambers here? You're Joe Chambers? I'm sorry?
Joella Chambers.
Joella Chambers, okay. On the record in the matter of Joella Chambers versus Lynette Farr, that's 23-02425. The council can have your appearance, please.
Good morning, good afternoon, Your Honor. James Gromer, P63503 on behalf of the defendants.
Okay, and I do have Joella Chambers here in court present. Today's the date for a pretrial. This is a general civil matter. The typical format for this is that I have the parties meet privately, and we can get you, Ms. Chambers, on Zoom for this purpose to complete a joint pretrial statement. The joint pretrial statement is a standard form that's created by the court. And it goes over certain things so we can figure out how to best set your next court date or deadline. Do you understand that?
Yeah, really good. A little more.
I'm sorry, I can barely hear you, ma'am.
I apologize.
No worries.
My voice comes and goes on a number of things. Counsel,
You want to hire an attorney?
I have to. It's going to be complicated. I've been trying for several years, considering as far as who was representing them and who holds the property, you know. In light of his passing, I apologize for the sound.
So you would like some time to get an attorney?
Yes, yes. But for some reason, she refuses to speak for herself.
I'm sorry, who refuses to speak to her?
Lynette Clark,
She's hiring an attorney. She has the right to counsel, just like you have a right to counsel.
but I filed a civil suit, and she can't have an attorney on the civil.
She can have an attorney in a civil suit. She can't have an attorney in
I
a small,
apologize, I
in a
apologize.
small claims matter.
That's what I mean, and yeah, I apologize, literally have a hole in my head.
I'm sorry to hear that, ma'am. This was removed from
I-
small claims.
Right, and she didn't show up, which means she's supposed to lose by default. She lawyered up afterwards. I was told that day. We even have, there's some people in California that has a show that actually invited us out there for this case. She declined it. She don't want to speak for herself. The truth has to come out. She keeps lowering up, and the courts keep changing laws for her. Small claim court, she has to show up. She didn't show up. She didn't retain counsel till afterwards. Because of who owns the property and who was managing the property, it's bigger than me. I've been blackballed. I've been trying to get a lawyer for decades, but at least since I've been in this city against them.
Okay, I just want to address a comment that you made, that
Yes,
the
ma'am.
courts keep changing the law for her. I don't know what you're referencing. I see, ma'am, that this was filed in small claims, which
Yes,
is how
ma'am.
you filed it.
Yes, ma'am.
However, there was a demand filed shortly after that to remove it from small claims to general civil. So there,
I
it
don't
never,
understand
don't
that.
cut me off, I didn't cut you off.
I apologize.
So there was never a hearing held before the magistrate for small claims. It was removed from that jurisdiction to the jurisdiction of the general civil division of the district court. And so that's how I have the case. This is a standard procedure. No laws were changed by the court to allow this as recourse or an opportunity for the party to remove it to this court. And based on what you said, in your own terms, it's very complicated. So if I had a complicated matter someone was suing me for, I'm a whole judge and I'd hire an attorney.
Apologize, I misspoke.
So I want to address that. No laws were changed for the benefit of anybody. We're following the court rules. And I would agree, if you believe it's a complicated matter, you should seek time to get an attorney if that's what you want to do. Otherwise, you have an uphill battle navigating the rules and the rules of evidence to try to prove your claim. Because obviously she's hired an attorney and I'm sure he's familiar with the general civil process, okay? So if you want to hire an attorney, I can reset this date to give you an opportunity to get an attorney to come in and meet with counsel for the defense so that you all can come to a joint pretrial statement. Otherwise, if you are unable, you have the option of proceeding on your own, but again, you'll be required to understand how the court process works. And then we'll proceed with your pretrial at that time, okay, ma'am? So I'll get you time. How much time do you think it'll take you to get you an
At
attorney?
least 60 days of court right now in between. Because of this, I'm homeless. Because she put it on my credit report, and then the courts, we made agreement that she would.
The courts made an agreement that what?
Back here in November 7th, 8th, I think it was 7th.
Of last year?
2018.
No, 2018.
There was an agreement in court that I would move. They wouldn't put this on my credit report.
You had an agreement
With
with not the
Riverfront.
courts.
We made an agreement in court.
Okay,
I apologize.
okay, you
Yes.
had an agreement as part of an eviction of some sort?
Yes, ma'am.
Okay, and you believe that that was breached?
Well, on both sides, really, because I'm sick. I was sick before, I got sicker after, because of it. When I was supposed to have moved out, it was during bad weather time. And because of my illness, but during that time, I endured a lot of dealing with these people.
I can imagine. So you're requesting 60 days to hire an attorney?
Yes, ma'am.
Okay, counsel, I'm not sure if you're making an objection to the request to adjourn this for 60 days.
No, Your Honor, but can I make a comment?
You may.
I've never had the pleasure of meeting with Ms. Chambers. I did file a motion to remove and an answer at the same time because I wasn't sure of the service date of her complaint because I didn't see it served. I would have normally filed a motion immediately, actually a summary motion, and then this case just sort of sat. But if Ms. Chambers isn't going to seek counsel, and Ms. Chambers, I see that what I see you asking in your complaint is something on your credit report for 500 and some odd dollars. I would likely resolve that with you. I do notice that you put something about your credit report for 562, but then you were asking for $5,000. I do think you should seek counsel first, but otherwise I would meet with you and probably be able to help with that 562 credit part.
105,000.
No, that's what he said. He said that you were requesting 5,000. He's not addressing that issue. What he is saying is that if your other issue is about what's on your credit report, he is open to discussing that with you to resolve that, if that can resolve the matter. But you go seek counsel first. And we'll note that. I'm sure that he will, hold that opportunity open to you. And then when we come back to the next court date, if you meet with him or if your attorney meets with him, maybe that resolves the matter.
Yes, thank you, sir. It's my thing.
It-
I need that clarification. My head
No
is
problem.
banging right now. and
No
I'm
problem, because
kinda-
you're spinning it too much.
Yeah.
No, you don't, try not to overthink it.
And Judge Simmons, would you prefer? I would normally. I don't want to intercede and file a motion. Would you prefer I wait till the next court date and then ask for a motion date, or would you entertain
Yes, if you can
filing
wait
it?
for the next, court date, and that way I can get her opportunity to see if she can get an attorney.
Okay, Judge, thank you very much.
No problem. Yes, please.
January 3rd at 2 p.m.
January 3rd at 2 p.m. work, counsel?
Yes, it will, Judge.
Okay, we'll set it for January 3rd at 2 p.m. We'll get you a notice for that date. Do you have any questions today? Okay.
Thank
Okay, any additional matters for the record, counsel?
No, Your Honor. Thank you to you and your staff.
Thank you, you're all set.
Bye.
Yeah, you can have a seat back there, you're all set, okay? We'll get you a notice in just a moment.
The screen left. Yes.
She was just supposed to be waiting for a notice.
Yeah, she walked right out.
You can mail it to her. Thank you, yes. Okay, let's see. One of these has a. Mr. Sparks, you're here for LVNV?
That's correct, Your Honor. LVNV versus Campos.
Oh, because there was a dismissal submitted, I think, for the other one, okay. Arturo Campos here? Yes. Okay. This is a pre-trial. Did you all do a joint pre-trial statement already?
Oh, we have not, Your Honor. I did receive your email with the form for us to complete if we went into a breakout room.
Okay, do you have a phone with you to get on Zoom? If not, we'll get you on our iPad. Okay, let's get him in a private meeting. And sir, what's your name? Okay. This is,
Sorry, is that Zoom, is it Zoom workplace?
I'm not sure, she can help you.
Is it Zoom workplace?
So I'll put it. So many files in here. Names. Okay, on the record in the matter of Midland Credit Management versus Irvion Smith 24-04867. Council, can I have your appearance?
Afternoon, Your Honor. William Hill, P 28608, appearing as coverage counsel for Midland Credit.
And Irvion Smith is present in the courtroom. Today was the date scheduled for a control date for hearing. I'm not 100% sure why we set it for control date. Typically, I would have done that if there was a request to set it out to possibly resolve the matter.
May I shed some information that they've given to me?
Yes, please.
Okay, the notes I have here said that Irvion Smith set up a payment plan with Midland, okay, on October 14th, okay? And this first payment was to be $10 to be paid on the 14th. I'm reviewing it and I see that a $10 payment did in fact come in, okay? Thereafter, the payments would be $50 per month on 10/31/24, and then the next $50 would be 11/30/24. Then it would escalate to $203.95 a month beginning on December 31/24. Total judgment amount would be $11,734.96. So if this is correct, maybe we can establish this on the record. I would say that this was a lawsuit based upon a loan that was taken out in November of 2022. Payments were made for 1 year and then defaulted. At the time they sold it to Midland Credit, there was $11,853 that was owed. Midland has sued on it. No interest has accrued on this since that time. But Midland seems pleased with the offer made, and if that's correct, we can perhaps enter into a consent judgment.
Is that correct that you made a payment plan?
Yes, $10. It went in a checking account. I was unaware that had to be in a checking account. I was given my savings account, so that's why the $10 hasn't been made. But it should be made today. You got through the checking account, so everything should be set up. That
okay. Okay, so you do want to enter a consent judgment. Judgment enter into today for the amounts that's stated on the record. You want to do that? Okay. Okay, counsel, can you give me those amounts or the total amount again owed?
The total amount owed was $11,734.96. It appears as if $10 has been paid on that, which we would reflect in the consent judgment. An additional payment is going to be due in a couple of days on the 31st, which would be $50. We could, if the court would allow us to assign the defendant's name to a consent judgment, we could e-file it to the court for entry today. But the judgment amount, judgment amount was $11,734.96, and then there were various payments.
That's the amount you're agreeing to as judgment, sir?
11,000.
Yeah. $11,734.96.
I don't know the exact down to the cent, but I think it's over 11,000.
Okay, so you're not disputing that at all. Okay, and you're gonna waive your right to counsel to proceed this way?
Yes.
Okay, and are you gonna give counsel for the plaintiff permission to sign this agreement on your behalf? Do you have any questions for the court?
I don't know. I know he just said that I have a payment due on the 31st of this month, but we made that payment today. The payment is due on the 31st. Okay, cool.
Okay, any other questions that you have?
No, that was it.
Okay, so then we'll get a copy of that signed by you, counsel, through my file, correct?
Correct.
Okay, any additional matters for the record today?
No, Your Honor.
You're all set. Thank you.
Thank you.
Thank you, counsel.
Thank you.
Okay, did you all come to a, no worries. I'll remove it. Okay. Did you do a joint pre-trial statement or come to a resolution?
We did reach an agreement, Your Honor, and we did fill out the pretrial statement very briefly. I don't know if you want that filed or not, considering we did reach an agreement. Mr. Campos agreed to a lump sum payment of $790 within the next 30 days. And once that's received, we'll go ahead and file a dismissal with the court.
Okay, very good. You can hold off on the joint pretrial statement if that's what you're going to do. I'll set this for a control date just to make sure we get the paperwork. And then that'll resolve the matter. That's how you want to proceed, sir?
Yeah.
Okay, do you have any questions? No. Okay, any additional matters today, counsel?
Nothing further, Your Honor. Thank you very much.
Thank you, you're all set.
Thank you. Thank you, Mr. Campos.
Thank you.
You're free to go, sir.
Thank you. It's good seeing you again. You probably don't remember me.
I don't.
I was here